Hello everyone. Today we are here with a video regarding reviewing IP clauses in a contract. Now in this video I will take you through three different agreements and typically how IP clauses are treated in these different agreements. The first agreement is the employment or consultancy agreements. Now, typically, if you are engaging a consultant or if you are hiring an employee, then there would be an intellectual property section in your agreement. Now, the first thing which you need to do in such an agreement is to have a work for hire language stating that the services being provided by the employee or the consultant are in the nature of a work for hire and the work product created shall be vested in the employee or the client per se if it's an individual consultant. Now, the employer solely and exclusively shall own the IP created. Firstly, in the work product that is being created or the final work product that the employee or the consultant creates, along with any copies, modifications, derivatives, and across all the formats. So that tomorrow you don't run a risk that the employee or the consultant is going to copy the work that they are doing and go ahead and make a similar product or service out of it. Now, secondly, if there is any concept which they are working on during the course of the employment, which may or may not be specifically assigned by you to them, which is done during the working hours, then even that should be included within the IP clause. So that if tomorrow, if your employee is sitting in your office and they end up creating a product on working hours using the employer's resources, then the IP in such product or service should vest in you. The third point is that the employee and or consultant, they should waive all moral rights. So as they are the creator of the IP, they would have certain moral rights automatically. Now, the agreement should specifically ask them to waive any and all moral rights. Apart from these, there should also be an assignment of IP clause there. In the event there are any IP rights which do not automatically go to the employer or which are not covered under any of the points given here, then the employee or the consultant will execute an assignment deed and they would assign all these rights perpetually and irrevocably in the employer or the client as such. Now, service agreements. Service agreements also run very similar. Apart from the fact that here it's a principal to principal agreement, the employer and employee relationship does not exist here. Now, here too, the work for hire language should come in, that the services or if any product is being created, then the same belongs to the employer, to the client. It's the exclusive and sole exclusive IP of the client, and it's in the nature of a work for hire. Similarly, there should be a perpetual, irrevocable assignment of all the intellectual property rights in the product or the service being created, provided that the product or service being created is specifically being created for the client. If the service agreement is of such a nature where the client is engaging the service provider, for example, to enable the services of a product already created by the service provider, then the assignment of IP doesn't come into picture. And typically, such nature of agreements fall into either licensing or subscription-based agreements. Now, waiver of moral rights. Again, the service provider would need to specifically waive off the moral rights to the product or service being created so that later on the service provider does not claim the intellectual property in this. Now, exclusivity to use the said product. So, for instance, if a specific product is being created specifically for the client, then you need to protect that the service provider does not tomorrow create a competing product or start selling the same product to some other client or uses the same technology again to create the same product. So, language in order to prohibit the service provider to do so should also be built in the service agreement. Now, licensing agreements. Under licensing agreements, intellectual property becomes important. It's also a little tricky because here there is no right of ownership being granted. So the ownership rights of the product or the service being licensed remains with the licensor itself. The licensee only gets a limited license to use the said product or service. Now, there is no right of ownership granted. The rights are defined till the extent of the scope of the license. So the scope of the license could be defined as anything, such as using the particular product, or maybe in some cases even sub-licensing, or maybe transferring the particular product, etc. So, in the intellectual property clauses in a licensing agreement need to be very carefully crafted, keeping in context the scope of the license. Now, in certain licensing agreements, white labeling rights are also there, where the licensee can put their own logo on a product or a service that they have licensed from a licensor. So, again, if a white labeling right is there, then you need to have clauses that protect your logo or your brand name that's being white labeled on the product. Also, if you are a licensor and you're giving white labeling right to the licensee, then also you need to make sure that the IP, that just because I'm allowing the licensee to white label the product, does not mean that the licensee has intellectual property or ownership rights on the product itself. So basically, those protections will need to be built in the contract. Now, licensor would need to warrant the IP ownership. So if I am taking a product or a service from a licensor, now I need to make sure that the licensor owns all the intellectual property to that particular product or service. So representation and warranty to that effect would also need to be included here. Now, IP indemnity would also need to be provided, because tomorrow, if I am using a licensed product and a third party claims that this particular product infringes a third party intellectual property, then I should be adequately protected. And therefore, an intellectual property indemnity becomes critical in a licensing agreement. I hope the slideshow was helpful and the video was informative for all of you. In case you need me to create a more detailed video around licensing agreements, please do let me know. Thank you, and have a very nice day.